Hello guys and welcome to the LawPutra YouTube channel. Our today's topic is pleadings. I am Jagannath Kulkarni and today we will discuss about the pleadings. What do you mean by pleadings? We have to refer to the Code of Civil Procedure 1908's Order 6 and Rule 1. It says pleadings can be plaint which is submitted by plaintiff, or it can also be the written statement which is submitted by the defendant. So basically pleadings include both plaint as well as written statement. So it is a statement of material facts, and by material facts what we mean or what we generally refer to is the facta probanda, which means the facts which are required to be proved, and not facta probatia, which means the facts by means of which they are to be proved. Simply, it is the particulars or evidence. So, the pleadings must not contain facta probatia, it must contain only the facta probanda, that is material facts. It should be in writing, obviously. Then it should be drawn up and filed in a court. Again, obviously, because you have to continue the suit, institute a suit in a court of law. And then it should be by each party to a case. So pleadings cannot be one-sided, it has to be the both-sided or each-sided. Also, it is the beginning stage of a suit. So this is the first foremost stage of any suit in which both parties, plaintiff as well as defendant, they formally submit their claims and defenses. Obviously, the claim will be submitted by plaintiff and defense will be by the defendant. Plaintiff submits a complaint. That's why it is called as a plaint. And it states the cause of action, why he is compelled to or why he is required to take that action. Or it can be the issues in controversy, both way. So that will be covered in the plaint by plaintiff. And the defendant submits an answer stating his or her defenses and denials, both. Either he can deny the cause of action or the issue in controversy, or he can put up his point. He may also submit, the defendant may also submit a counter claim which will mention the cause of action against the plaintiff. So the case can be vice versa also. Also, it is by pleading, it is an act of a person, it is action of a person who pleads. It is advocating of a cause in a court of law. It is art or science, whatever you can say, of what setting forth or drawing, what pleas in legal cases. So this is the statements, these are the says of both the parties. It is a formal statement. Normally it is written and it sets forth two things, either cause of action by plaintiff or defense by defendant of the case. The successive statements which are delivered alternatively by plaintiff and defendant until the issue is joined. So this is very important. These statements can go on continuing. It can be in succession till the issue is joined. Now let us talk about the objectives. Now after knowing the meaning of the pleadings, let us talk about the objectives. It serves an important function of providing notice. So basically it is a notice to whom? To the defendant that a lawsuit has been instituted against him. So this is the main purpose or important purpose of pleadings. Pleadings also provides notice to whom? To the plaintiff of what? Of the defendant's intentions in regard to the suit. So this is the both way. Firstly, it will be notice to defendant. Secondly, it will be notice to plaintiff. The objective of pleading, if you see, it aims at ascertaining precisely what points of contention of parties to a suit. So this is very important. Then it gives a fair notice or intimation of case to opposing party, both way, enabling that opposite party to produce evidence to the issue disclosed. It enables the courts to determine what is really at issue between the parties to prevent deviations from the course which litigation cause of action has to take. So this is important. So why pleadings are important in any suit is this. Firstly, it is the notice or intimation. Secondly, it mentions the points for both for the plaintiff as well as for the defense. Then only we cannot deviate from the course which is intended to solve that issue. Now let us see what it is mentioned by the courts. Court says pleadings are required to enable the court to decide true rights of the parties in trial. The parties can claim anything, but what is the true claim that we have to see. And it is said by someone, and that is the Supreme Court. In one of the case, that was Ganesh Trading Company versus Mojiram, it is 1978 case, and Supreme Court records in volume 2, Supreme Court reports in volume 2, we can find this case. Supreme Court said procedural law. Now we know that this code, civil procedure as well as criminal procedure, these are the procedural laws. So this procedural law is intended to facilitate and not to obstruct the course of substantive justice. So substantive justice is our ultimate aim, and procedures are to facilitate, not to obstruct. Provisions relating to pleading in civil cases are meant to give to each side, plaintiff as well as defendant, intimation of the case of the other, so that it may be made to enable the courts to determine what is really at issue between the parties and to prevent the deviations from the course which litigation on particular causes of action must take. So this is the facilitation of delivering the justice, ultimate justice, and it facilitates the job of the courts. Now let us see what are the essentials of pleadings. After knowing the meaning and objectives, let us see the essentials. Pleadings must state material facts and not evidence. This we have already seen. Now we have to refer to Rule 2 of Order 6, Code of Civil Procedure 1908. It says, Sub-Rule 1 says, every pleading shall contain only a statement in a concise form of material facts on which the party pleading relies for his claim or defense, as the case may be, but not the evidence by which they are to be proved. So this is the first and foremost condition required, that it should be the statement in concise form of material facts. Then Sub-Rule 2 says, every pleading shall, when necessary, be divided into paragraphs, numbered consecutively, each allegation being, so far as is convenient, contained in a separate paragraph, so that there shall be clarity of the case for the court as well as for the opposite parties. Sub-Rule 3 says, dates, sums, numbers, whenever we are covered numbers or integers, they shall be expressed in a pleading in numbers as well as in words. So this has to be both way to make the fact clear, to have the ultimate clarity. Now in essentials also, these are some fundamental principles or general principles we can say about the pleadings. First thing is that it should state facts and not acts, that is law. So pleadings is about the facts and not the law. Then the facts stated should be material facts. It should not be evidence, it should not be those facts depending on which these material facts are to be proved. And they should not state the evidence. Obviously, you have to give only material facts. Evidence, let the court will do it in course of action, it will find it out. And the facts should be stated in a concise form. So remember always these four things. It should be fact, it should be material fact, it should not be evidence, and it should be in concise form. Now let us talk about the signing and verification. This is very important. We have to refer to Rule 14 of Order 6 of Code of Civil Procedure. It says every pleading must be signed by the party or by one of the parties or by his or their pleader. So signature is important. Whatever is mentioned in pleadings, someone has to own the responsibility, and when you sign it, you own it. If the party is unable to sign the pleading for any good cause, then it can be signed by any person authorized by him. But remember, every pleading must be verified by the party or by one of the parties or by some other person who is acquainted with the facts of the case. So remember, signature is important, verification is equally important, so that the person signing owns the facts which have been mentioned in the pleadings. Let us summarize. If you want to know about the pleadings, we have to refer to the Code of Civil Procedure 1908 Order 6. It contains 19 rules. The first rule talks about the meaning of pleading. Second rule talks about the pleading to state material facts and not evidence. Third rule talks about the forms of pleading which have been mentioned in Appendix A. Fourth rule talks about particulars to be given where necessary. Rule 5 talks about the further and better statement or particulars, but this rule have been omitted on 1st July 2002. Then Rule 6 talks about the condition precedent, what was happened in the past. Then Rule 7 talks about the departure from what is mentioned in the pleadings. Then Rule 8 talks about the denial of contract. Rule 9 talks about the effect of document to be stated. Rule 10 talks about the malice, knowledge, etc. It need not give the evidence. Then Rule 11 talks about the notice. We have seen it earlier. Rule 12 talks about the implied contract or implied relation. Then Rule 13 talks about the presumptions of law. Rule 14 talks about pleading to be signed. Rule 14A talks about the address for service of notice. Rule 15 talks about verification of pleadings. And Rule 16 talks about striking out the pleadings which are vexatious or frivolous. And Rule 17 talks about amendment of pleadings. And finally, Rule 18 talks about failure to amend after order. So in all 19 rules, but one has been omitted. We are referring to Order 6 of Code of Civil Procedure 1908, and we will discuss today the pleadings. Thank you. Thank you very much.